I did not hear what the state said they heard.
I didn't hear it either. All I can hear is that last little bit.
Yeah, I'll tell you that I heard one or two things.
That's what I thought I heard, but I can't be certain.
Wasting taxpayers' money over Woody's mumbo jumbo.
And I can play the game. If you read it in context, that's what makes sense. Literally says the game.
I gotta be able to hear it.
Yeah, and I was like,
That's what makes sense. So we're just assuming because of context. Did she actually just say that? Days 96 and 97 of the Young Thug YSL RICO trial were tedious. The defense and state went through hours of interrogation footage and had the judge rule on what was admissible. Shout out Thugger Daily for tweeting this. Judge Glanville has moved his show calls hearing to July 3rd. This hearing is for him to determine if anyone other than Brian Steele should be held in contempt as a result of the ex parte hearing. He will also be holding an in-camera private transcript review July 1st. So the judge is dragging this out. I mean, just release the transcript. What are we doing here? Why aren't the transcripts done? It's an ex parte meeting that apparently took place in like 10 to 20 minutes. A very big red flag, but let's get right into the court footage for the day.
Mr. Copeland testified. Detective Gaither were forcing him to name a suspect. Majority of this interview is her trying to encourage him to tell what he knows. That is, again, in contradiction to what Mr. Copeland has said on the stand, that whether they were forcing him, they were not. And you can see throughout the conversations here.
I said that in my video last week. He's been the only one talking.
You know, that Tay never killed me. I think he said, I swear on my child's grave, on my mom's grave, that Tay never did it. So I think this is relevant, one, to contradict Mr. Copeland's in-court testimony that they were forcing him to do anything.
If you go to the street's trying to kill you. I ain't going to the street. I'm going to get you working with this. I'm like, what? The first time you would have told me. But you're not telling me nothing, because I'm in jail.
Investigator Gaither is essentially making an argument that the jury will hear that it's a future dangerousness argument. It's an argument that, you know, you're either on the side of the quote unquote gangsters or you're on the side of the people that are trying to protect children. It presents a false dichotomy, and also it invites the jurors to consider things that are not supposed to be in their purview as the finder of fact. Again, it improperly presents this dichotomy of where the police are the good guys and the protectors of children, away from, you know, the bad guys who are out warring in the streets. And I just believe that that's an improper statement. A, it's not true, but B, it's an improper statement.
I mean, she's got some basis to ask him, appeal to him in terms of what he, you know, what's going on.
So clearly the judge is letting it in. All right, let's move on.
My issue is the state trying to appeal to the jurors through their questioning, and I'm sure they're going to make arguments in closing. They made arguments in opening that witnesses are reluctant, that Mr. Copeland's reluctant. They're pointing out that Mr. Copeland says certain things when Jeffrey Williams is in the room versus not in the room. The reality, despite insinuations at times by the state outside the presence of the jury, there's been no evidence that Mr. Copeland fears anyone seated here. There's been no evidence of any threats made by anyone seated in this courtroom towards Mr. Copeland, or at least on the defense side. Here, Mr. Copeland is clearly expressing fear of being a snitch, being labeled a snitch, the ramifications of telling, but what's important here, and I'm afraid what might get lost, is Mr. Copeland is expressing fear of an entirely different group of people than the accused here today. The group of people that are shooting at him actively, I think the state has alleged, are if gang members. I believe that certain individuals that are not associated with any of the defendants here today eliminate any of the misleading or confusing issues from this tape, including this segment right here, which for, you know, under 403, I believe that it should be excluded.
The Schardt saying it's misleading.
I think Mr. Schardt is trying to compartmentalize issues, and we have to look at this case in the totality of all the circumstances. But also, he talked about not being afraid of snitching. He talked about the fact that whatever he said in these interviews, he was just saying it just to say it. I asked him, was he concerned about snitching, being labeled a snitch? He said, I was not. So this is impeachment by contradiction and prior inconsistent statements, both. Because I, on direct examination, asked him, was he concerned about snitching? He said, no, I wasn't concerned about snitching. They were forcing me to say, they were forcing me to point out Tay. They were forcing me to do it. Gaither forced me to point out Tay. He literally talks about why he cannot identify Tay because he's going to be labeled a snitch.
Low-key making a good point here.
Snitching is relevant in this trial in the totality of the circumstances. Mr. Copeland is talking about his reasons for not wanting to snitch, which is very relevant in the totality of this case. So for multiple reasons, we believe that this portion should be allowed to be played.
All right. Any other counsels wish to be heard on this?
The judge is going to let all this in, 100%. He's going to let anything in. I mean, some of it is a jury issue that the jury needs to decide if they believe it or not. Woody was lying on the stand. He was acting dumb, scared to snitch in person when he snitched 8 years ago or whatever on camera.
The state's information about people come in and face Mr. Williams et al. Then are reluctant. It's not what I understand. I understand Ms. Bennett was upset because the district attorney's co-worker was inappropriately communicating with her. I understand that Mr. Bean told another detective at the hospital when he was first arrested that he did not have information. He was told if you include Mr. Williams, then you can get out. It'll be better for you.
I forgot Adrian Bean was told that. And someone in the DA's office was being a creep with Miss Bennett.
Because the motivation of Mr. Copeland is clear. He's in custody. He wants to get out of custody. And he's making statements. These are not prior consistent statements at all. The state is saying it's prior inconsistent statements. Sometimes they are, but sometimes they're really prior consistent statements that they wish to get in, because Mr. Copeland really is not inconsistent. He said, yes, I probably said these things, but I said them because I was motivated to get out of jail.
He did say that. He was like, I may have said it. If it says I said it, but I don't remember. It's not really inconsistent, technically, if you think about it.
So the state is relying on inconsistency. I believe that they're really relying on consistency.
Snitching is relevant before the jury, and whether or not that is an issue that several witnesses have testified to would be relevant. So, but of course, primary ruling is based upon impeachment by contradiction. So that will be authorized to be inquired into.
No surprise, judge letting it in.
And Mr. Copeland says essentially now or when I got locked up, and he said that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it.
That's what you said you're gonna take out? Because that talks about the Twitter conversation. All right.
They are asking about when's the last time he hung out with Shannon and Lil D, who's the Mickey on Garlington, and he says, not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds, probably thousands of hours reviewing the discovery in this case, the they he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th. It seemed like Shannon and Lil D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things that I said earlier, this is not a normal trial. First of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played.
The state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we thought of. And so we'll play the whole section so you can hear it in context.
You know, I just listened to it again. I was thinking maybe I missed something. He says there's no discussion of other people shooting at the car. They say, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. I mean, it sounds like my client shot at a car.
Honestly, yeah, for a jury to hear that, it could get confusing.
So I mean, I understand your concern under 403. I respectfully disagree at this point, but
of course you do,
because I
Judge.
don't think it'll confuse them. But
No surprise, he doesn't think it'll confuse them.
Kelvin Watts told his girlfriend, or a girl that he knew at the time, whose name's Trivia, about what had happened, and apparently made some confession, according to Mr. Copeland. And then Trivia tells Kenneth Copeland. So it's double hearsay.
Damn, that's crazy. Kelvin told a girl about something he did, then she went and told one of his ops. That's crazy.
Kelvin Watts to Trivia would fall under a hearsay exception. Trivia to Kenneth Copeland would not fall under hearsay exception. So it's hearsay.
Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. While hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this. Defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews.
Sheesh. Woody definitely lied at some points, though.
and this kind of historical perspective.
At this point, then it's cumulative.
Doug looks sleepy as hell. Look at this. I did not mean to pause it on his face, bro.
Sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant.
Judge took like 20 minutes in silence and then says he needs a comfort break. Just take a shit, I guess.
The defense's assertion as well as cumulative, because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think, briefly in January 28th and February 20th, that he's reiterating these events to different investigators.
What's your ruling, Judge? We've been waiting 45 minutes.
I'm going to permit the inquiry area.
Impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them.
All right, in considering both sides' arguments in regards to 401 being relevance, 403 being unduly prejudicial, or in the state's assertion that is impeachment by contradiction, the court does find it is relevant.
Are we surprised at all that the judge has ruled in favor of the state throughout the entire day of day 96?
Investigator Gaither talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, you know, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be neutral. And that's the impression that the jury is given when they're exposed to, again, the speech. I call it a speech, but whatever you want to call it, by Investigator Gaither. Look, it's, you know, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. It invites them to take into consideration factors that should not be considered in that jury room.
Again, you have to look at this in totality around her. This starts off with Mr. Copeland saying, why do I have to go through this, man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation. So I can continue my investigation. I can continue my work. That's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court he said they made him say Tay. That's not true. That's what this shows as well.
Your Honor, I don't see why this adds anything. I join everyone else, Shardd's argument. The detective said to kick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement offered to bolster the detective, and that's really not appropriate in my opinion, and it's irrelevant under 4012, and then 3 would be waste of time. A lot of this, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
Welcome to Fulton County, where they want to play 18 hours of interviews. So incredibly pointless. I'm sure the taxpayers are thrilled.
I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction.
Surprising. Judge ruled in favor of the defense for once today.
Or this out-of-court statement by Mr. Copeland, my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland as payback. Mr. Copeland is essentially saying that Shannon has encouraged him and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence. And what the state wants, essentially the logical conclusion based on hearing that is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
Easiest decision I'll make today. So we'll work on, now, as it pertains to, since we'll probably take most of the day with that, I'm inclined not to call in our juries. I'm inclined to just tell our jurors have a nice week.
So you just said there's no jury for the week of 24th through 28th. At least the jury gets an off week because their lives have been for this long. And next week is 4th of July. We're not going to have witness testimony for weeks. This trial is a shit show. Which
leads me to July 1, 2, and 3. More than likely, we'll probably use for the jail calls. We'll probably take that up on Monday, the 1st of July. Tuesday, we'll probably do the in-camera review of Mr. Copeland's ex parte.
Dude, if I was a Georgia taxpayer right now, I'd be livid. This is because the DA is trying to play hours and hours of interviews that I'd say 99% of it is pointless. Like, there's maybe 1% that's relevant to a RICO trial. That's it for day 96. Let's go on the day 97. First look at Thug on day 97. Him and Shannon are talking about something. This June 10th interview is the 9-hour long interview. I'm sorry, but I'm not going to sit here and watch it because the audio is terrible, and I'm not going to watch it until the jury is watching it. I'm just going to skip past it and see what they argue about and see what they nitpick out of it, because this shit is terrible audio. Brian still has something to say about something. Here we go.
Have Detective Dennis as well as Detective Gaither projecting their beliefs and thoughts. And by that I mean Detective Dennis and Detective Gaither told Mr. Copeland that they do not believe when he claimed that Jeffrey has not given him any money except for $1,000, and that they did not believe him when Mr. Copeland said that he's never committed a crime for Mr. Williams. I also object to the detective. It's saying that their belief is of summarizing what Mr. Copeland was
He just signaled at someone, Thug did.
trying to say is that Mr. Williams looks at Mr. Copeland. Mr. Copeland is bringing Jeffrey down, or Mr. Williams down, quote unquote, and therefore they latch on to Mr. Copeland when he said that he heard that Jeffrey put a contract on his life where would have him killed. So that's why I'm objecting. I asked Mr. Schardt to include that. I'd like that removed. And Mr. Copeland hearsay saying that he heard that Mr. Williams would have him killed. So those are the reasons that those...
How he learned of the fact that he thought Mr. Williams wanted to harm him. And it's not so much what Valerie told him, but what he did with that information. Even on page 63, he doesn't go into detail about what Valerie told him. She said I think Valerie told him he's trying to set you up. What he does with that information is he approaches Yek, which is one of our co-defendants sitting in the courtroom today, Mr. Kendrick, to ask him about what he had just learned. And so we believe that this portion, whatever Valerie told him, isn't being offered for the truth of the matter asserted, but the effect on the listener, which is after hearing this, he went and asked Mr. Kendrick about whatever it is that Valerie told him. And then Mr. Kendrick then assured him that that wasn't true, that he isn't trying to harm him. And the jury should be able to ascertain whether or not they believe that this interaction occurred. And so that isn't hearsay, that's personal knowledge of this event that took place that at some point in time when Mr. Copeland was in the presence of Mr. Williams, a police officer called him, and he's explaining...
Called him being who?
Called Mr. Copeland. So Mr. Williams and Mr. Copeland are present with each other. A police officer called Mr. Copeland in his presence. And he's telling the police officers his understanding of what that interaction meant to him. And again, that is relevant as to why he was concerned about why he thought Mr. Williams wanted to harm him. Again, because he was talking to the police too much.
Let me just ask, just to make it, see if I can clear my mind. Are you saying that the officer called Copeland and Mr. Williams happened to be present for the phone call?
Yes.
Okay.
The judge doesn't remember that. Woody talked about that on the stand for like 5 minutes.
Also, the state keeps saying that Mr. Copeland gave this blanket assertion. I lied, and I know I heard what he said today. That's not what he said. What he said was, I probably said all of these things you're asking, but I said them because I wanted to remove, this is my impression, the target for me under 403. I don't know why the detective's words get to be displayed to the jury on, oh, well, you had to have committed crime, Mr. Williams. That's Mr. Williams' character under 408. And it's also a 403 analysis.
He made something like I killed. It don't matter. What I'm saying is, this is what you would see me if I said, I told you that already. They both do the same thing.
Why do they have such bad microphones in these goddamn rooms?
All right, gentlemen and lady, any further objections? The state says they're going to admit that. So,
Mr. Copeland, when he's telling some of these stories, he begins with, this is what they said, and there's not a clear delineation from when he is speaking on what other people said to where he's speaking out of some sort of...
None of that should be allowed in. If it's not his personal knowledge and it's what other people said, that it should not be allowed in.
To where he's speculating. They come in too because they saying Birdman wanted to sign Bloody J. So it begins with...
That's line 3.
Yes, so it begins with they saying, continues to talk about business relationships, who he calls Thug and Birdman, and then he's asked about gang membership and rankings of different individuals in the gang, including Shannon, Mr. Kendrick, and Jeffrey. They say, what's Thug's ranking? But Thug ranking, Thug ain't blood. They say he won't answer the phone for them. And so it's they say. So it seems to be based on hearsay. And then they ask about what rank he's claiming, and he says, SHIT, last I heard, like, because Shannon's supposed to be G-Shine, and Yak's supposed to be some other blood set, some. So I don't think it would be appropriate to play such flimsy evidence with a source that's cannot be determined.
Impeachment by contradiction. He says that everything, he made it all up. So I start there. Then secondly, when he's talking about who is a part of what set or what gang, Mr. Copeland hangs around or is around all these people all the time. That's
but we don't know who. I mean, it's they.
Right, but I think that is just the way in which he speaks. I mean, he's around Mr. Kendrick. We've seen pictures of him with Mr. Kendrick. He's around Mr. Williams. We've seen pictures of him around them. So he has an understanding of what they call themselves or what they identify as.
But who is they, though?
And so we don't believe that they is a third party telling him something that he's unaware of. We believe that he has knowledge, personal knowledge himself, being that he hangs around or that he's with.
Making their own determination that favors their theory of admissibility, but that doesn't shine through in the transcript or in the recording. What does seem clear from the recording is Mr. Copeland is getting information from somewhere else, and he also really doesn't know what he's talking about, or at least he claims to not know what he's talking about. He says, whatever it is, I don't know about that. So he's just in, we all know people like this that say a lot, and then at the end of that long statement about everything say, but I really don't know. he says, and they was like Thug saying everybody. So the they is in apparently telling, the unknown they is now telling Copeland what Thug supposedly said. So,
dude, what the man? The state nitpicks at so many minor sentences, it makes me want to jump out a window, dude.
Audio, and I'm inclined to agree with the defendants that we don't know who they is, and for that reason, I'm gonna exclude that particular part of the that to be played.
Judge rules in favor of the defense.
the shooting of Mr. Bennett's mother's house, the detective talks about a gun that Quindarius Zachary matches the ballistics coming back to the shooting of Mr. Bennett, who we've called Lucci before, his mother's house.
That one was bad. A YSL member getting caught with the gun that the ballistics match that shot up Lucci's. That's bad.
What I think is inappropriate is if this discussion enters evidence and the state is not going to produce any witnesses that make the ballistic match between a gun and the shooting at Mr. Bennett's mother's house.
We do intend to introduce ballistic evidence showing that that gun matched the ballistics from the second shooting matched the gun that was found on Quindarius Zachary.
This part of the statement should be redacted.
I would concur. Until that evidence is actually put forth in your case in chief.
Yeah, that makes sense.
You still need to lay some more foundation in regards to the ballistics for that to be then testified to. Folks, you want to stop here given the fact it's right at lunch?
They come back 2 hours later. Why?
Counsels, thank you for your patience. I had to take up some business. It took a little bit longer than I expected. So I think we left off.
So a couple things that I object to with this. Obviously, it's character evidence about my client owning and possessing a gun based on my client's status as a convicted felon at that time. That would be an illegal act. We have not been given any 404B notice about this previously. So that's my first objection. It's not charged conduct either. A foundation hasn't been laid to play this portion of the tape. The state did not confront Mr. Copeland and say, in the interview on June 10th, 2015, did you tell Investigator Gaither that after being shot at that outside your house, that was Shannon's gun, Shannon took the gun, Shannon wouldn't return the gun, etc. He's never been confronted with those prior statements, so I don't think the foundation has been laid.
Yes, the foundation has been laid about the gun.
How's the foundation been laid?
Because when he says, I don't remember anything that I told the police, coupled with everything that he is saying, he made it all up. That is the foundation to which we get to play his prior statement.
Does he have to be confronted
No.
with it, as Mr. Schardt mentioned?
He does not. The moment that he says, I don't remember anything, we can confront him with all of his statements, especially when he says, I don't remember anything I told the police and everything I said to the police, I was just making it up. We don't have to confront him with every single line in his statement, and I'll find the specific case law that states that.
Is a convicted felon, meaning his possession of a gun would per se be a crime. And the jurors, as the state has made it clear by admitting probably 4 prior convictions of Mr. Stilwell, they've made it clear to the jury that Mr. Stilwell would have been committing a crime if he was in possession of a firearm. That's the difference. It is bad character evidence. All of this is subject to 403 balancing. The state is labeling this as intrinsic. We have a murder case from January 2015. Then we have
It's extra. It's so extra. Everything about this case is extra.
unrelated shooting case upon Kenneth Copeland at his house, which happens, the state, I understand their theory, but there's really been no hard evidence that shows that these 2 events are at all linked. So now we're getting into the weeds of what happened to a gun in an unrelated shooting that happened around the same time, where the target was Kenneth Copeland, and what happened to the gun that he used to shoot back at the people that were shooting at him. We're way off in left field at this point, of very limited probative value as to who killed Donovan Thomas on January 10th, 2015. And I think we need to keep that in sight and what we're actually trying to prove and what this case is about.
He is saying actually the opposite. I probably did say all that. Let me explain to you why. If they want to get into specific, like Shannon had the gun, Mr. Jackson, had the gun, then I would also join Mr. Schardt and say that he needs to be given an opportunity to say, did you say this? And then he'll say, I assume, yes, I did say this. Why did you say it? Because I lied. And then you don't have to play the report.
I'm going to ask you one other question. What say you about the extra?
I see Steele's point in here, but the judge ain't gonna go with this.
I could possess a gun like I could possess this highlighter. It's not bad character. But Mr. Jackson, in this case, is a convicted felon before this June 10th, 2015 interview. So clearly, that is criminal activity. I think that answered your question. So I do believe that it is the character, inappropriate character of Mr. Jackson.
He said, everything I said back in 2015, I made it all up so I can get out of jail. So now the jurors get to see what he said previously in order to determine if they believe him in court or if they believe him when he talked to police back in 2015 that he made it all up. If we're impeaching him by contradiction, we are saying what he told his jury in 2024 is contradicted by what he was doing in 2015. The opposition gang believes that he killed one of their gang members, uses a gun that was given to him by Shannon Stillwell, is one inextricably intertwined into this case. Although it's inextricably intertwined, and although it incidentally places his character although it places Mr. Stillwell's character at issue, it is inextricably intertwined into the overarching story and conspiracy that we are attempting to prove in this case, Your Honor.
So we are now going into the minute details and collateral information about a act that isn't even among the 191 acts charged. Secondly, even if we were to label this as intrinsic, which I don't believe it is, the state said it's admissible as long as, even if it incidentally at issue. This is more than incidentally.
Let me just engage in a little conversation. Ordinarily, you'd be right, but there's a background in terms of this gun. The jury's heard and is continuing to hear in this particular case, and that being is that in the interview says, well, Copeland, I tell the police anything they want to hear because I want to get out of jail. I'm gonna go get that gun. This kind of fills in that particular narrative about this particular gun. So it is kind of relevant, and it is kind of inextricably kind of intertwined in that respect. Well, they're trying to complete the picture about the weapon.
I understand what.
Okay, and I know you fundamentally disagree. And
well,
let
me just say a couple things. First of all, this weapon, I think this is important to know. This gun is not involved allegedly in any other crimes or acts. So there's no loose ends that need to be tied up later with who had this gun or where was this gun. This gun, the story about this gun ends here.
So you're saying the state's trying to complete this story about this weapon, and this weapon is not used in any way in this particular case?
There's no story to complete about the weapon. The weapon is a dead end. Nothing happens with that weapon. You know, I could see if this weapon was used in another crime and they need to track it. This weapon is not part of the story at all. It's not intrinsic.
The state's intention is not to impugn that this gun was used in any other offense.
Well, the jury might think that, Ms. Hilton.
What it does is it increases the prejudice in terms of because you don't want the jury confused on the fact that, okay, we've heard Shannon's got a gun, or that Copeland's saying, hey, Shannon, the reason I didn't turn it in is because Shannon took it and he took it down he took it. But it doesn't go anywhere because it's not used in any other thing. It's not used in any other criminal offense. It's not tied to a murder. It's not tied to anything. It's just the fact that this shows where this gun went on a guy that's already who's a convicted felon, and it's not charged in the indictment. I didn't
think the judge would do it, but he's actually leaning towards the defense, I think. I mean, this is just going to confuse the jury.
My concern is Mr. Schartt's concern, and that's whether or not it's more prejudicial than probative, given everything that he's charged with. Is this going to confuse the jury or let them know, hey, what about this weapon when it's not tied to anything in the indictment? I'm inclined to apply the 403 balancing test and find it's more prejudicial than probative. But here's the take, defense. If you open the door as to it, I'm gonna let them bring the truck. You'll need to talk with Mr. Copeland about that. He needs to make very clear that he cannot mention Shannon or anybody else.
And again, given his current...
So they compromised and got that solved, all right?
He being Mr. Copeland, is explaining that it's not me, it's Shannon. And he doesn't say his name. That's when he points to the paper. Because it would appear that on the paper, Shannon's name is on the paper. And he says, this is your problem right here. Whatever he says, he does. And he points to the paper. Presumably, Mr. Williams' name is on the paper and Mr. Stillwell's name is on the paper. They then go in to ask him, how much is he getting paid? He says he's not getting anything. They ask him, well, who told you that? And he says, he points at Shannon, because Dennis clarifies, he says Shannon. This goes into Copeland's belief of why he doesn't understand why he's being targeted by IFGang. Because
He being Copeland?
Correct. And he's explaining that I'm not the problem. It's Shannon is the issue. Talking about two other gang members and the relationship between them. We believe that is relevant for the jury to hear.
I know your objection. I'll allow the state to play the order of objection. I'll give you a continuing objection.
Source of information when he was talking to the police was D. I take that to mean there's two Ds. I take that to mean Lil D, meaning Demekion Garlington.
But we don't know.
We don't know for certain. It could also be Quindarius Zachary or another D, but if he got it from someone who must have got it from somewhere else, and so we're just kind of rehashing rumor and hearsay. Or Mr. Nipsey Hussle, who's now deceased. It's certainly a story that he tells that I think there's internet rumors and speculation and everything else.
Anything Woody said about Nipsey Hussle and the game should not be in this trial. What are we doing here?
On personal knowledge, anything more than me Googling street rumors and then saying this is what happened. So there's no personal knowledge. It should not come in. It's hearsay. It's speculation.
Stop that.
I think it's, all right, this is what I hear. Shannon says I was up there waiting. One more time?
So there's some discussion about there being an admission of a party opponent here.
The game is I don't know so Central has probably so that went.
Just give me a word.
Yep. And so no say turn on the GD I think Nielsen, he just heard something like that. He ain't the game is I don't know so Central has probably so that went. The game is I don't know so Central has probably so that went.
Just give me a word.
Yep.
So I forgot the state is saying there was a beef with the game and Thug and Shannon or something.
The GD I think Nielsen.
This trial's so long, I forget certain things like this. Like, I remember that being a part of the trial like 5 months ago. I don't know what he's saying. They just keep repeating the clip, a 7-second clip. No one can understand what he is saying, dude.
The last part, that last sentence, I can't hear the first part.
And I don't hear what the state's saying, and I don't even hear enough syllables to get to what the state's saying. Indictment where an overt act alleged is the shooting of a high-profile hip-hop entertainer's tour bus is included. This statement, the admission of this statement, is highly prejudicial against my client. I don't hear anything in the statement that cures the hearsay aspect of this statement. I want to get out of jail. That's how he ends this. Right when the state's turning it off, he says, I want to get out of jail. He's giving all sorts of information that he knows, but he's not a lawyer. He's not limiting it to personal knowledge, and he's passing on hearsay that he thinks he knows, I should say. And it shouldn't be admitted for that reason.
Listening to that, the number of times I listened to it, I did not hear what the state says they heard.
I didn't hear it either. All I can hear is that last little bit.
Yeah, I'll tell you that I heard one of two things. Either Shannon was on Metropolitan waiting for him, or Shannon was probably up there waiting.
That's what I thought I heard, but I can't be certain. I can't be certain because I can't hear the first.
We're really sitting here wasting taxpayers' money over Woody's mumbo jumble mumbling words, dude.
Right, I'll tell you, I'm not 100% certain. It's one of those. I know I didn't hear. The state said they heard. Shannon told me out of his own mouth. I didn't hear that.
You're right. And I can play the game. If you read it in context, that's what makes sense. Literally says the game.
I gotta be able to hear it.
Yeah, and I'll play.
That's what makes sense. So we're just assuming because of context. Did she actually just say that?
The game was fixing to get his ass shot up. If Thug would have told Shannon to do it. Shannon told me and I'll play it again, out of his mouth, he was up there waiting. And Dennis responds, just give me the word. Copeland says, yep. And Thug told him no. So when you read that in context, that is the only thing that he would have said is Shannon told me that he was waiting for him. And we can play it one more time.
That's not a good reason, in my opinion.
The game begins. Shannon told Shannon to do it. Shannon told his mouth to do it. Told Shannon to do it. Shannon told his mouth to do it. Just give me a word. Shannon told his mouth to do it. Told Shannon to do it. Shannon told his mouth to do it. Do it. Shannon told his mouth to do it. Shannon told his mouth to do it. And do it to no. Say turn on the GD. I can't Nipsey.
I'll be honest with you. I don't, Miss Hilton. I do not hear out of his mouth anywhere. But I have to be honest and say I don't hear. I get beat. I like Mr. I get little bits and pieces of Shannon, and then waiting for him. I don't get like that. The rest of that sentence that fills in. I can't hear it, or at least not now.
He's giving information, but he's not saying where he got it from, and I'm not just going to agree that his source is Demekion Garlington and therefore it's a statement by a co-conspirator.
I think that would go to weight, not admissibility. He talks about the fact that Demekion told him everything that occurred, which would include what happened with the cars after the murder and where they went after the murder, Your Honor.
There's not a lot of corroboration that Demekion Garlington is the source other than Mr. Copeland's statement itself.
I understand what you're saying, Mr. Schardt. I'm still going to admit it over your objection.
Reputable suggestion that Mr. Williams or any of these other gentlemen have intimidated witnesses in this case. So I think that's an improper comment on Mr. Williams' character and through proxy my client, Mr. Stillwell's character as well.
There should be no talk about witness intimidation because there's zero evidence of it. I know common sense says that it could happen, but there's no evidence that Thug has done shit.
It's commenting on pre-arrest or post-arrest silence because it is generally the context of the state arguing if this person was innocent, they would have done this.
So you said that already. So you're saying that or applies when you got a defendant?
Yes.
Okay, not a witness necessarily. All right, Mr. Steele, unfortunately, I'm going to go back to my original ruling. So I'll note your objection and that you cited or once again.
Yeah, that's pretty much it for day 96, 97. It looks like the next week or two of this trial is going to be pretty tedious. I'm going to try to cut it down to the most entertaining possible part, but I just sat here for 4 hours and I want to jump out the window. So hit subscribe. Love you guys. Peace out.